You're half asleep in a hotel room at 11 at night, phone charging on the nightstand, when three sharp knocks hit the door. Through the peephole, you see two police officers, no warrant in their hands, no hint of what they want, and your heart starts pounding because in that half second, you're trying to remember something you've never actually been taught. Do they have the right to walk into this room, right now, without your permission? Most people assume a hotel room is basically borrowed space, like it belongs more to the hotel than to them. That assumption is wrong, and it's wrong in a way that surprises even people who think they know their rights. Because the truth is, the moment you check in and shut that door, the law treats that room almost exactly like your own home. And what happens next in that hallway can determine whether evidence gets thrown out of court, whether your rights got violated, or whether the police were completely within their authority the entire time. Here's the first thing that catches people off guard. The front desk clerk downstairs, the manager, even the owner of the hotel, none of them can legally let police into your room. Not because it's a nice courtesy they extend to guests, but because the United States Supreme Court settled this question decades ago. In a case called Stoner versus California from 1964, police showed up at a hotel, didn't have a warrant, and asked the night clerk to let them into a guest's room. The clerk said sure, unlocked the door, and officers searched the place and found evidence they used to convict the guest of robbery. The Supreme Court looked at that and said absolutely not. The justices ruled that a hotel guest is entitled to constitutional protection against unreasonable searches and seizures, and that protection doesn't disappear just because a hotel employee happens to have a passkey. The clerk had no authority to give away rights that weren't his to give. That ruling matters because it tells you something bigger about how the law actually thinks about hotel rooms. It's not treating them as some kind of gray area between public and private. It's treating them as an extension of your home, protected the same way your bedroom is protected. That protection comes from the Fourth Amendment, which guards against unreasonable searches and seizures by the government. And the test courts use, going back to a 1967 case called Katz versus United States, isn't about who owns the walls. It's about whether you have what's called a reasonable expectation of privacy. When you pay for a hotel room and lock that door, you have every reason to expect that what happens inside stays private. Courts have consistently agreed. So if the hotel can't authorize a search and you haven't invited them in, what actually gives police the legal green light to enter? This is where it gets layered because there isn't one single rule. There are several different doors, so to speak, that can legally open, and each one works differently. The most straightforward one is a warrant. If police have gone to a judge, laid out facts establishing probable cause, and gotten a signed warrant specifically authorizing entry into your room, they can come in whether you like it or not. That's the system working exactly as the founders intended, a neutral judge checking police power before it's used. But warrants take time, and time is something police don't always have, which brings us to a concept that shows up in almost every serious Fourth Amendment case: exigent circumstances. This is a legal way of saying an emergency existed that made getting a warrant impractical. If officers reasonably believe someone inside is in immediate danger, if they hear screaming or a struggle, if they're in what's called hot pursuit of a fleeing suspect who just ran into a room, or if they believe evidence is actively being destroyed at that very moment, they can enter without a warrant and without your consent. The Supreme Court reinforced this in Kentucky versus King in 2011, ruling that police don't lose the exigent circumstances justification just because their own actions, like knocking loudly and announcing themselves, might have triggered the emergency, so long as the police didn't create that emergency by violating the Fourth Amendment or threatening to do so. That case matters because it shows how much judgment gets left in the hands of the officers standing at your door in the moment, which is exactly why documentation and body cameras have become so important in disputes over what really happened. There's also what's called the emergency aid exception, which the court addressed in cases like Brigham City versus Stewart in 2006 and Michigan versus Fisher in 2009. If police have an objectively reasonable basis to believe someone inside needs immediate help, they don't need a warrant and they don't need your permission. Notice the word objectively there. It's not enough for an officer to just say they had a hunch. Courts look at the actual facts available to them at the time. Now, here's where most people's assumptions really start to crack. What if you're not alone in that room? Say you're traveling with a partner, and the two of you disagree about letting police in. One says yes, one says no. Whose answer wins? This exact scenario reached the Supreme Court in 2006 in a case called Georgia versus Randolph. A husband and wife were both present at their home when police asked to search it. The wife said yes, the husband, standing right there, said no. The court ruled that when one occupant expressly refuses consent while physically present, that refusal controls, at least as to that occupant, even if someone else with equal authority says otherwise. The logic is almost common sense once you hear it. A police officer standing at a doorway with two people disagreeing in front of them can't reasonably treat that as a clear yes. But there's a critical detail people often miss. This protection only applies if the objecting person is physically present and objecting at that moment. If your travel companion isn't there, maybe they stepped out for coffee, and the person present consents, that consent can be valid because the refusing party isn't there to refuse anything. There's another twist buried in the law here. What if the person who says yes isn't actually authorized to say yes, but the police reasonably believe they are? This came up in Illinois versus Rodriguez in 1990, where a woman who no longer lived at a residence and had actually moved out let police in using a key she happened to still have, telling them it was still her apartment. It wasn't anymore. The Supreme Court ruled that a search is still valid if police reasonably believed, based on the facts available to them, that the person had authority to consent, even if that belief turned out to be mistaken. This is called apparent authority, and it means the legality of a police entry sometimes hinges not on the objective truth of who controlled the room, but on what a reasonable officer would have believed standing in that hallway. Bring that back to a hotel setting and things get interesting fast. Imagine you're sharing a room with someone, and that person, without you there, lets officers in and tells them it's fine. If police had no reason to doubt that person's authority, courts may treat that consent as valid, even if you would have said no. Now, let's talk about something that trips up almost everyone because it feels like a technicality, but it can completely change the legal picture. Checkout time. You've probably never thought about the constitutional significance of a hotel's 11 a.m. checkout policy, but courts have. Generally speaking, as long as you're a paying, current guest with a valid reservation, your expectation of privacy holds just as strong as it would in an apartment you rent. But once checkout time passes and you haven't paid for an extension, haven't renewed, and the hotel considers the room vacated, many courts have found that your reasonable expectation of privacy can end along with your rental period. At that point, the hotel regains control of the room, and hotel staff may be able to let police in, because legally, you're no longer the one with a protected interest in that space. This is exactly why some cases hinge on something as unglamorous as a front desk computer log showing whether a guest paid for another night. So picture this. You overstay checkout by a few hours because you're packing up slowly, nobody's called your room, and police show up asking the manager to let them in. Depending on the jurisdiction and the specific facts, whether the hotel had already re-let the room, whether staff had begun cleaning it, whether your belongings were still inside, a court might find that your privacy protection had already lapsed. This is one of those areas where the answer genuinely depends on the details, and no honest legal explainer should tell you it's a hard, universal rule. It varies by circumstance and by how courts in that state have handled similar situations before. Let's shift back to the moment at your actual door, because that's where most people feel the most uncertain. Say officers knock, no warrant, no emergency that you can see, and they ask if they can come in. You are under no legal obligation to say yes. You can decline a police request to enter your hotel room the same way you could decline a request to search your home. And simply saying no is not an admission of guilt. It's not obstruction. It's not suspicious behavior in the eyes of the law. It is a right, plainly and simply. Here's a phrase worth remembering because it's short enough to say even if your hands are shaking. Officer, I do not consent to a search. You can say it calmly, you can say it while opening the door slightly to speak with them, and you can still be completely polite while saying it. These two things are not in conflict. Being respectful and asserting your rights are not opposites. In fact, staying calm and clear is exactly what protects you, because if officers do enter anyway, without a warrant, without exigent circumstances, and without valid consent from someone with authority, your clear refusal becomes powerful evidence later if the case ends up in court. Anything found after an unlawful entry may become inadmissible thanks to a legal principle called the exclusionary rule, which is designed specifically to prevent illegal searches from being rewarded with usable evidence. But there's a difference between refusing consent and physically resisting officers. If police say they're entering regardless, whether because of a warrant you haven't seen yet, an emergency they believe exists, or simply an assertion of authority, the safest and legally smartest move is never to physically block them. You can object verbally, you can ask to see a warrant, you can ask for their names and badge numbers, but interfering physically can turn a civil rights violation you could have fought in court into a criminal charge against you. The battle over whether entry was lawful is a battle for lawyers and judges, not for a hallway confrontation. There's one more layer worth knowing, something that separates confident, informed people from everyone else in this situation. If police do enter and start searching, try to remember details. What did they say when they knocked? Did they mention a warrant number? Did they claim an emergency? And if so, what emergency? Did hotel staff let them in? And were you present when that happened? These details matter enormously later because Fourth Amendment cases often turn on exactly this kind of specific, factual reconstruction of what happened in the first 60 seconds of an encounter. So let's pull all of this together, because by now the picture should be a lot clearer than it was at the start. A hotel room is not some legal no man's land where your rights evaporate the moment you check in. The Supreme Court made that explicit in Stoner versus California and reinforced it through decades of Fourth Amendment cases. Hotel staff cannot authorize police entry into your room. Police generally need a warrant, valid consent from someone with actual or apparent authority, or exigent circumstances like an emergency or hot pursuit to enter without your permission. If you're present with someone else and you object, your objection can override their consent, at least as it concerns you under Georgia versus Randolph. And your privacy protection is strongest while you remain a current paying guest, but it can weaken once your stay legally ends. None of this means you should ever escalate a situation with law enforcement. Compliance with lawful orders, calm communication, and clear verbal assertions of your rights are what actually protect you, both physically and legally. The people who come out of these encounters in the strongest position aren't the ones who argue the loudest. They're the ones who stayed composed, said the right words, remembered the details, and let the legal system do its job afterward. Knowing this doesn't just protect you in some rare hypothetical. It changes how you walk through the world, how you travel, how you understand what actually happens when a badge and a knock show up outside a door you thought was completely yours. Because now it is, and now you understand exactly why. If this kind of deep dive into your rights during police encounters is something you want more of, there's another video on this channel breaking down exactly what happens when police show up at your front door after a 911 call, even one you never made, and whether they can legally walk inside without your permission. Given everything you just learned about hotel rooms, that one might surprise you even more.